Joseph Cosgrove.
Thank you, Carl, and thank you for this opportunity to speak to the public, to speak to members of the bar, and thank you for getting us all together. We've traveled thousands of miles across this Commonwealth, and we've become friends over the past few months, and it's too bad there were not 5 openings on the court. But there are 2. I'm sitting currently in one of those seats. I was appointed last year by Governor Wolf to sit on Commonwealth Court, so I'm the only person here, I'm the only judge here who's actually serving in Commonwealth Court and has a different perspective on it, doing the work of the court, doing the work that I'm seeking. And today we had oral argument, and I remember every time I go into session, put on that robe. The robe is a heavy garment, and it's thick, and it should be. It reminds us of the weightiness of the law and our duty. And I'm honored to be in that position, honored to have the Bar Association's highest recommendation. I'm the only Democrat with that highest recommendation, and I'd be honored to continue to serve for an elected term.
So modify slightly, why do you want to continue serving?
Well, I appreciate that. And, and this court, what makes it unique in many ways is that it is a hybrid court. It is equal to Superior Court in rank in our judicial system, but not only is it an appellate court, it's a trial court. And about 15 to 20%, depending on the year, of our docket is original jurisdiction matters. And those cases are important, and many of them are handled at the summary level, the preliminary objections or summary judgment level. So there's a trial aspect to that, which I have a unique qualification for. I've served on the trial bench as well now as on Commonwealth Court itself. So I can understand this in a different way. We only have 2 other judges on the court right now, of the 9 commission judges, who have also served at the trial level. And that's important that we not lose that perspective, because it's a very important and vital part of our jurisdiction. So I want to continue in that capacity, but my background and my experience has been in the appellate system, not only in the Superior and Commonwealth Court, but the State Supreme Court, as well as the Third Circuit and U.S. Supreme Court. I sat in second chair a few years ago and filed many briefs of amicus and merits briefs. So I have an appellate background as well as my trial work as a lawyer for many years and my trial work in Court of Common Pleas. So I'm uniquely qualified for this position, and with your help I'll stay there. Commonwealth Court is unique in so many ways. One of the ways is in the fact that we vote on every case. In a Superior Court or different federal courts, the panels will deliberate after argument, or if it's a submitted case, and render their decision, and the rest of the judges will learn about that when it's issued, whether it's a published opinion or a non-published, non-precedential decision. In our court, we review every decision before it's filed. And if there are 4 of us of the 9 who disagree, even if the panel were unanimous, if we disagree, then that case will be submitted to conference, and we'll discuss at conference, and it may then go to an en banc discussion or en banc argument, which we had today and where I sat today. So that process can tend to complicate things, but it's complicating it in a good way. It means the entire court has had a view of this, and the entire court has had a voice in this, whether the opinion is ultimately going to be unanimous or whether it will be issued with a dissent. But those are important things, because that invites then the Supreme Court to take a look at the case and know that we've all had a view of it. I would say that one thing that I think we should do more of is have more oral argument. Unlike Superior Court, sort of the default position is that the case will be argued. All the litigants have to do, the counsel has to do, is just check a box. We would require, if it's going to be submitted on briefs alone, counsel has to file a motion to request oral argument. I think we should have more oral arguments, have that default position like Superior Court. For the last 28 years, I've taught constitutional law at King's College in Cosgrove, Pennsylvania. I've been an election lawyer for the past 25 years prior to my taking the position on the Common Pleas bench. And these are areas that Commonwealth Court just thrives in. We deal with constitutional issues. We deal with election issues. You know, this is the court that decided several years ago that the voter ID law in Pennsylvania was unconstitutional. So that's my plate that I live on. This is the court that decided, the only court in the country that decided that Senator Ted Cruz was eligible to run for president, although he'd been born in Canada, since he was born to an American citizen. We're the only one who solved that perplexing problem with a very detailed opinion. So Commonwealth Court deals with these kinds of complicated constitutional election issues. I've also served as a zoning solicitor. I've served as a solicitor at the county level. I've litigated original jurisdiction matters for legislative caucuses from the Pennsylvania legislature in Commonwealth Court. So I have this background and experience as a lawyer, as a scholar, as an instructor, and also, again, as a common pleas judge and as a judge now sitting on Commonwealth Court. So I'm uniquely positioned to remain in that spot. We've talked a lot here about the precedential decision, the issuing of published opinions. The court took one step that at least is positive, but I think it could take other steps. Recently, and not that long ago, the court has issued a rule that allows the citation of the so-called unpublished or the non-precedential opinions for their persuasive value. That was something that litigators did anyway and tried and would say, we understand this is an unpublished opinion and it's not precedential, but you should take a look at it. And the court would always in a footnote slap them back and would take it under consideration. So now the reality has just been made rule-based. So that's one step, but the publishing the opinions is important. Part of the hesitancy is, as I can see from the inside and know this, part of the hesitancy is that sometimes the analysis of a case is not as deep as one would want to set the rule in a particular direction. Sometimes the case doesn't really call for that. I'm sure Judge Chancellor has seen this at the trial level, that not every case has the magnitude that should set a precedent. So that would be one area to analyze those, but I think also developing a different oral argument system and having more on-bank arguments. Those are important. Those are really valuable. And again, with 7 of the 9 judges presiding, I think that we could really set a good trend, and I would hope to see that. One of the most important decisions last year involved all levels of our government and the people themselves and how we self-govern. And that was the case involving the question of whether the proposed constitutional amendment that raised the mandatory retirement age for judges from 70 to 75, and whether the procedure that the legislature had implemented was appropriate, constitutional, and whether the question could go on the ballot. If you remember, there was an awful lot of political dynamic behind all this. The amendment was supposed to be on the spring ballot a year ago, and then the legislature pulled that. All kinds of discussion as to why, the question of whether it could be pulled, whether it was appropriate, or whether it should have been decided in the spring. In the primary season, that was before one of our judges with a single judge decision. Ultimately, it was decided that indeed the amendment could go on the November ballot, and it did, and passed with a very small majority, but passed nonetheless. Well, regardless of whether you think it was a good idea or not such a good idea, that's going to impact us for a long time. It certainly impacts us here because there would have been 3 rather than 2 seats on Commonwealth Court. The other major decision in the past few years has been the Robinson Township decisions, a series of decisions that have greatly expanded the perspective of the constitutional rights amendment that is part of our Constitution, dealing with fracking, dealing with pipelines, and other things. I'm in the unique position of having been merit selected for the position I'm in. And that was a rigorous process that Governor Wolf had established. He had a commission, bipartisan, lawyers, non-lawyers, stakeholders in the community, and that commission analyzed all of the applicants and the candidates. I believe there were 46 for these positions, and from that I was recommended and the governor chose me, and then the Senate controlled by a party other than the governor's, and I was unanimously confirmed. I didn't have recusal issues with that. When I got to Commonwealth Court, I did have to disclose to our clerk any lawyers that I had a particularly close relationship that I practiced law with, things like that, clients that may appear before the court. They are on an automatic recusal list. So for the first 6 months of my term, I did not have to deal with the issue that this question poses. But now I do. So I deal with it as all these candidates are, but I'm again in that unique position that I'm not looking at it as what I will do, it's what I'm doing every day. I analyze the donors, I look at the donors, and I check every day when I'm reviewing those opinions that I must vote on. I check to see who the lawyers were the parties there, and if there's a conflict, I recuse. If there's not, I proceed. But it is a process that things like this, forum like this, having these all over the state by nonpartisan groups like this would be a really big help. At this level of review, it's all about the record. That's what appeals are. It's all about the record. It's the four corners. It's, as the Pathonetary's office says, if it's not in the box, it doesn't exist. If it's not in the record, it doesn't exist. But fellow trial judge and fellow trial lawyers here at the table, they all know that the agency record is not the same as a trial record, for example, in a criminal case or in a civil personal injury or other case like that, where lawyers are litigating and there are witnesses and there's exhibits and there's all kinds of detail and the record can be voluminous. Oftentimes at the agency level, that record is terribly sparse. Deference, yes, we know the standard. We know that three-pronged standard. But I've heard it said, when a court reviews a lower court opinion, it cleans its glasses and it looks carefully. When it reviews an agency record, agency decision, it still cleans its glasses, but it wears bifocals. We are the first court. We are the first independent judicial body to review an agency, a different branch of government's actions. And so that must be taken quite seriously. We have different standards. We have different ethics. We have different rules that guide us. And that must be taken into consideration. When I was appointed to the Court of Common Pleas, I actively sought out from the minority communities throughout the state, throughout the country, law clerks. I've hired the first African-American law clerk in Luzerne County in 150 years. It was sad to recognize that had been the case. We had a law clerk in the 1850s who was denied admission to the bar because of the color of his skin when he had clerked with the court. And we changed that, and we admitted him to the bar posthumously. I've worked with civil rights groups for the entirety of my career. One of the highlights of my career was working with Cesar Chavez in the United Farm Workers in California. I had the touching honor to sit with him during his last fast. He was famous for his fasts for justice. He was fasting over the mistreatment of the agricultural workers in California, and I sat at his bedside during that time, alone with him. So I have fought for the civil and human rights of everyone. Our court needs to do more. How we do that, it's very difficult to say. We need to openly recruit. This is a problem that the U.S. Supreme Court deals with. I don't believe now, at this point, I'm not sure there's any African-American clerk at the U.S. Supreme Court. At least there had not been until recently. We need to do more in our active recruiting, working with those agencies. There's a group called CLEO that is active in helping with those recruiting processes, and I worked with them previously. We need to do that as a judiciary. I've had two governors who dealt with vacancies. They could have chosen any lawyer to fit within the jurisdictions to fill those spots. I was appointed, nominated, and then both times, Senate controlled by an opposing party unanimously confirmed me. The first time was in Luzerne County after the infamous Kids for Cash scandal, which is still staining our judicial process. And I was asked by Governor Rendell, he had a simple mandate, go and restore the integrity of the judiciary. Not a small task. But myself and my two colleagues who were also appointed shortly after, we did that. And then when another vacancy occurred on Commonwealth Court, I was asked by Governor Wolf to serve, nominated by him out of all the individuals, all the lawyers who had applied, and he chose me, and the Senate from another party unanimously confirmed me. The Pennsylvania Bar has, among all of the candidates on the Democratic side, I'm the only one that is highly recommended, the highest recommendation from my peers at the Pennsylvania Bar, and I'm honored by that. The Democratic Party, although I was not endorsed, I finished second in the balloting, but the committee that was established that did the interviewing picked Todd and myself and chose me. So anytime I've been vetted, I've been picked, and I'm asking for the major vet, and that's the voters, to vote for me.
Judge Cosgrove.
Thank you, PNC. Thank you, PBA, for hosting this. Thank you, PBA, for your high recommendation of me. Going to work every day on Commonwealth Court is the highest honor I could have as a lawyer in this profession. As an advocate, I knew I was always right because I was representing my client, and I took the phrase, represent zealously your client, to heart, and I did. Fought the fight all over the country. Now, it's even more important that I get it right, because the only client I have is the Constitution and the people. That's a pretty daunting position to be in, and it causes me to take a breath every moment before I render that decision. I've done the job, I'm doing the job. With your help, I'll continue to do the job, and I'll have the honor of serving with one of these good people next to me. Thank you.
Hopefully.